He's representing the Fight Back Foundation. They want their bond money. Something we really care about. About that, yeah. Okay, they put mics right there to see them. There's mics, yeah, medium mics. Just so. Don't give me your social security number or anything. 8675. 3 on it. Your PIN number is.
All right, this is the case of State against Rittenhouse.
The state appears by Assistant District Attorneys Thomas Binger and Jim Krause.
Good morning, Your Honor. Mr. Rittenhouse appears in person, represented by Attorney Mark Richards, Corey Shirafisi, and Natalie Wisco.
All right, and we've got a few technical problems this morning, and I'm on a different network than usual, which... Ms. Motley, you have your hand up? What's up?
Sorry, I was turning up my volume.
Oh, okay, no problem. Yeah, I'm on a different network. I don't think that'll cause any problems. The ordinary network we use was not coming up. So, and then I had to choose between, and I don't know why, this hasn't happened previously that I can recall. I had to choose between the courtroom view, which is what should be in the center right now, showing all of the lawyers, and if I move it around, all the lawyers and the defendant, and or views of myself, and I figured people would rather look at the courtroom than me, but so that's how it's set up at this time, and I could change it. But unless there's some reason, I'm not going to. So that's the technical report. And I'll now ask you folks to update me if there's anything since the last filing, and then we'll start taking on the nuts and bolts of the case and some of these motions which have been filed. So, Mr. Binger, have you got anything?
Judge, I just want to confirm with regard to the Victims' Rights Act, I know Ms. Motley was going to appear representing Mr. Grosskreutz. John Huber, the father of Anthony Huber, had been appearing in the past along with attorney Steve Art. I'm not able to see who's on your Zoom connection there, so I just want to make sure that we have everybody that needs to be here.
Yeah, I think Mr. Huber is on. I don't see...
I'm here, yes.
Yeah, and I don't see attorney Arts, and Mr. Grosskreutz is on, and Ms. Motley is on. Is there anybody else appearing? Let me make sure that there's nobody in the waiting room.
And Your Honor, just for the record, I'm also here on behalf of the estate of Joseph Rosenbaum.
Fair enough. All right, and...
We're not aware of anyone else who would be appearing, Your Honor.
All right, and what else?
Other than that, Your Honor, I don't have anything new since the last filing.
All right, Mr. Richards.
Yeah, I think we're all up to date. Everything was filed.
Okay. All right, why don't we take the motions up and then we'll talk about the progress of the case. The first one that I looked at and was received on in the first batch was a state's motion for other acts evidence. The state alleging that on June 1st of last year, the defendant assaulted a female in Kenosha, and I did review your briefs. Did you want to add anything to what's already in the brief, Mr. Binger?
Your Honor, I've reviewed the defense response brief, and I think that there is a notion that the defendant's state of mind is not relevant here, or that because there's really no dispute that these were intentional acts, that somehow the only issue remaining for trial is the reasonableness of the defendant's actions. That may very well be where we're at the end of the trial, but at the beginning of the trial, I have a burden of proof. There are claims against the defendant that go to his state of mind in terms of intent or recklessness, and it's my burden to prove that. At that time in the case, I won't have any testimony from the defendant. I don't know if he's going to testify or not. He doesn't have to. He has the right to remain silent. So I certainly can't presume what evidence may or may not come in the defense case. This is an unusual homicide case in the sense that it is not a whodunit. This is not a question of did the defendant kill anyone. The question is what was his state of mind and whether or not his actions were reasonable or not, and whether or not they go to intent or recklessness or some other mens rea. That is the mental state that the state needs to prove. We don't convict people without the requisite mens rea. So his state of mind is perhaps the most critical issue in this case. The motions that we filed, both this one and the other acts motion that we'll get to in a moment, illuminate the defendant's state of mind, both on the night in question and also on these preceding events of June 1st and August 10th, which is the date of the other motion, or the events of the other motion. And I believe that these motions help the jury to understand the defendant's state of mind. And I think that that is a relevant element, both in terms of the criminal charges here and also under State v. Sullivan, in terms of intent, motive, knowledge, absence of mistake, etc. The first motion that you've discussed, Judge, has two prongs to it. One is with regard to that June 1st fight. That is a fight which has been captured on video. It is an incident in which it's my understanding that the defendant's sister got into a physical altercation with another female. This was essentially a one-on-one fight, somewhat of a consensual fight. Both of them interested in assaulting one another. But in the midst of that, Mr. Rittenhouse intervenes and begins to add on to what his sister is doing to this other female by assaulting that second female. And I think that that goes to the defendant's state of mind in this case because it shows that his understanding of self-defense, his understanding of the need for self-defense is a certain way, and I think it's an improper and unjustified use of it. I also think it goes to what I will posit will be a strong theory of the state's case here, which is the defendant is essentially a teenage vigilante involving himself in things that don't concern him. And we have a common theme here, both with regard to this incident and the August 10th incident that's the subject of our second other acts motion. The defendant throwing himself into situations that don't concern him, that he has no complete knowledge of, that no one asked him to be involved in, and using force or threatening to use force in an unjustified, illegal, unwarranted manner. So I think with regard to this other acts motion, that June 1st incident illuminates the truth for the jury. It illuminates the defendant's state of mind. And the jury is going to have to consider that state of mind when it makes its determination here in this case. The second part of that other acts motion is with regard to the incident after a court appearance in January, where the defendant goes to a bar in Racine and is serenaded by members of the Proud Boys. Now, we have since learned that those individuals that were serenading the defendant consist of the highest echelon of the Wisconsin Proud Boys chapter, including their leader, their current sergeant-at-arms, their former sergeant-at-arms, and other high-ranking members of that organization. This was not a random crossing of paths here in a random bar at a random time where they just happened upon one another. This was something that was coordinated. This is something where Mr. Rittenhouse intended to be there. These other individuals intended to be there. And the Proud Boys organization is relevant to this case because we have to put the incident of August 25th in context. This was not a festival in the park where somebody suddenly pulled out a gun and started randomly shooting. Most everyone that was there on the streets of Kenosha on August 25th was there because of their beliefs, one way or another, with regard to the shooting of Jacob Blake. And I don't need to argue one side or the other. The court does not need to make a determination one side or the other. But we can't ignore the fact that people were drawn to the streets of Kenosha that night because of a response to the shooting of Jacob Blake. There were some out there that believed that that shooting was justified, some felt it was unjustified. There were other chaos tourists like the defendant who were drawn like a moth to the flame to our community. We've seen folks that have committed crimes under the cover of that chaos, burglaries and looting and arson. The defendant wasn't one of those people, but this was the type of person that was drawn to our community. The defendant, I believe, was drawn to this incident because of his beliefs, which are consistent with those of the Proud Boys. And I believe that those beliefs include a desire to use violence to support that philosophy. The Proud Boys are a well-known national organization that takes pride in using violence to achieve their means, that takes pride in showing up at rallies and protests by what they consider to be their opposition, which can be loosely considered to be Black Lives Matter or Antifa or whatever you want to call them, and using violence to disrupt those protests. The defendant came to our community. He's not a resident. He's underage. He's out after curfew. He's armed with an illegal weapon. Why? That is the question. His state of mind, his intent that night, is a crucial issue in this case. The defense will no doubt try and portray the defendant as an altruistic, young, idealistic individual who was here to try and help our community, protect a business, clean up graffiti, use his medical supplies to help people in need. They will try and show his state of mind as being a positive, helping one. The state is entitled to introduce evidence that further illuminates his state of mind for the jury. And the jury will ultimately make the decision as to his intent, his motives, his state of mind, what he personally believed at the time of these shootings, and they will introduce their reasonable impressions as our community members as to what a reasonable person would do in those circumstances. So those are the questions the jury is going to be asked. I believe a jury's trial is about the truth. I believe that these issues go to the truth of the matter. The jury can be advised as to how to consider the weight of this evidence. The jury can make its determination as to the weight and the relevance, the importance of, or the pertinence of this in terms of whether it's really a true description of the defendant's state of mind or whether the other side, portraying him in a different light, is the true portrait of his state of mind. But I believe the state is entitled to introduce these two pieces of evidence as part of our first other acts motion because it goes directly to these issues. Looking at the Sullivan factors, these are being sought to be admitted for a proper purpose. They are relevant to the issues at the trial, and they are not unduly prejudicial. They are close in time. They are directly relevant to the factors in this case. The court can give a limiting instruction as to the use of this evidence, which will also help to mitigate any undue prejudice here. But again, these are the defendant's own actions. He's responsible for his actions. What he did on June 1st, what he did at the bar in January in Racine, and of course, what happened on August 25th here. So for all those reasons, Your Honor, I believe that the court should grant our first other acts motion and allow the state to introduce these pieces of evidence as part of our case in chief. Thank you.
Thank you, Mr. Richards. Mr. Sharafi.
Judge, I'm going to address it if I could. Thanks. So as it relates to the first other acts on June 1st, so the state is asking you or inferring that they're able to ascertain Mr. Rittenhouse's state of mind 2.5 months prior to the incident. So his state of mind on June 1st and his actions on June 1st somehow play a role in his state of mind on August 25th. This is, as an officer of the court, this is what I'm telling you. Mr. Rittenhouse it will not be debated that this action was intentional. It will not be debated that the action was intentional, and he will raise the issue regarding self-defense. When we're looking at the purpose of other acts, intent is one purpose, and it's a proper purpose. However, intent is normally admitted if it undermines an innocent explanation for the person's behavior. That is not happening here. There is no innocent explanation. There's an explanation, but he fired the firearm intentionally. as it relates to motive, if they are trying to establish that he had some motive 2.5 months before, teenagers getting into a fist fight, does that make it more or less probable? Is it a fact of consequence that he was in a fight 2.5 months earlier, that he did not act in self-defense in this case? Does that make that more or less probable? The answer is it does not. It doesn't have anything to do with whether or not it makes it more or less probable that he acted in self-defense. The entirety of this is captured on video. The only issue in this case is going to be the reasonableness of those actions as they're determined subjectively and then objectively from a reasonable person in his position. So they describe him as being somebody who comes to Kenosha looking for trouble, even though they don't mention he works in Kenosha. He works in Pleasant Prairie. And that his father lives in Kenosha. And I would submit to you that when you look at the similarities, if we're really going to do a Sullivan analysis, the biggest thing in Sullivan that was different really was the manner and form in which one was a verbal argument, one was an assault. And if we have reached the position where teenagers getting into fistfights makes it more probable that a teenager then used a firearm in self-defense, when we have the self-defense on tape, we have the case on tape, I would submit to you it adds nothing to that determination as to whether or not his actions were or were not in self-defense and whether they were or were not reasonable under the circumstances. So where I believe it fails, if you believe it's the proper purpose, it adds nothing to the case as it relates to his state of mind 2.5 months later. And certainly because this isn't a whodunit, and it wasn't an accident, it is an intentional act with an affirmative defense attached to it. And I don't think under those circumstances, this particular instance has any relevance to that. All right? As it relates to the Proud Boys, I mentioned this in the brief, and Mr. Binger has ignored it.
Mr. Binger, what?
Binger has ignored it. For this to be considered by you, there must be evidence by a preponderance that on August 25th, 2020, Kyle Rittenhouse was either a member of the Proud Boys or had loyalties to that group. It is no different than you would make a determination if there was, for example, somebody wanted to introduce evidence of a gang membership. I'm telling you as an officer of the court, we have downloaded Mr. Rittenhouse's cellular phone. We have had an expert review that phone. That expert has done an analysis to try to determine if there is anything on that phone related to Proud Boys, militia, white nationalists, Boogaloo Boys, KKK, 3%ers, any type of hate group that you might consider. And the finding was the extraction does not establish that the user belonged to or even had any interest in any malicious-style organizations. Mr. Binger has provided you no information whatsoever that on the day in question, August 25th, that Kyle Rittenhouse had any affiliation with that group at all. He's asking that you take and allow evidence to be admitted over 4 months later about a photograph without any information that anything related to this case involved the Proud Boys. There has been nothing. And I have cited for this court cases in my brief related to, for example, gang memberships. And in every one of those cases, the court had to make the finding first the person is in fact a member of this organization or has loyalties to that organization. You've heard nothing in his brief and nothing in his argument today that would substantiate that on August 25th that fact existed. There has been interviews with witnesses, some of whom are admitted militia members, some of whom are admitted far right-wing have right-wing ideology, to a person none of them had ever heard of, talked to, knew of Kyle Rittenhouse prior to that day. None of them. So there is nothing in this record, and there's nothing that Mr. Binger can point to that should satisfy you to even do this analysis, meaning that there has been a showing by a preponderance that he has any of these affiliations. Okay? So I don't think they get there. However, if you're going to make the considerations as to whether or not they have provided that evidence to you by a preponderance, and we're going to go to the relevance standard, there is nothing that would indicate that any of these shootings were related to, he describes them as the Proud Boys as a racist hate group. There is nothing in this evidence that would support the idea that any one of these shootings was racially based. I mean, we have to remember the 3 people that were shot are white. The only racial statements that were made that's going to be in evidence in this case is of Mr. Rosenbaum. The first person was screaming the N-word during this. That's it. So to admit evidence that because he's a member or has ties to an organization which he's been unable to prove, that this somehow is a motive for the shootings, when unless they can tie that these shootings are somehow racially related to these 3 people, it doesn't add anything to whether or not it was done in self-defense. It is without debate, Judge. All 3 of these people were chasing Kyle Rittenhouse. All of them. That is not debatable. So for them to say the fact that he has, or they believe he has some tie to this organization, without any information that in fact that's the reason that this happened, it doesn't move the ball further down in terms of making something more or less probable, a consequence of fact. If they can't show that this shooting was related to that and argue that's the reason it wasn't in self-defense, I don't think they move the ball. And I think if you're really going to do the Sullivan analysis, what they're talking about is 4 months after the fact, people in a bar. There's no information that Mr. Rittenhouse knew who they were when the photos were taken. But he's having lunch and they're taking pictures. That is somehow close in similarity to what happened on August 25th. As I mentioned in my motion, my response, August 25th has been described as a war zone in Kenosha. The evidence in this case will be multiple people are armed, whether it's militia members, rioters, threats are being made amongst the groups, there's a curfew, there's police presence. You're going to use that and say having lunch and taking photos with people with no tie to that organization is somehow moves the ball toward making it more or less probable this was not done in self-defense. I ask that you consider it, as I said, much like courts consider membership in other organizations. There has to be some tie to it before you would allow it to be admitted. I would finally, in this particular case, talk about the unfair prejudice without a tie to it, without some information that he's part of this group, and without some information that this these shootings were motivated by hate or race, it is the probative value of that is substantially outweighed by its prejudicial value. We are hoping to try this case on the facts, and to admit evidence that bears nothing moving forward on the case, other than to say he has some ties to some hate group, even though there's no proof the shooting was related to a hate group, I think would wildly prejudice the jury as it relates to the facts of the case. So I don't believe they've, certainly as it relates to the Proud Boys, I don't even think you get to this, Judge, unless Mr. Bringer can point to some indication that on that day there's a connection that he can actually put forth in evidence. But otherwise, I believe the evidence is not relevant, should not be admitted. The first one is 2.5 months before, the second one is 4 months after. And I don't think it would assist the jury in any way in this case in making that determination, and I would ask that you deny the motion.
Thank you. Well, I'll tell you, with respect to both of these requests, I think if I admitted either of these, I'd get reversed. That's the bottom line. I think that the first one, the incident involving the sister, this is clear, in my estimation, it's a propensity evidence. It's an opportunity to suggest to the jurors that he's acted in a violent way on other occasions, and therefore he acted in a violent way on this occasion. There's no connection between these two events at all. They're totally dislike each other. One involves a fight involving some kids, including the sister of the accused, and how he reacted in that particular instance, which has nothing to do with what happened in an incident which, and I haven't seen all the videos that you folks have had, or seen witness statements as you have, but it sounds like pretty clearly that at the time that the first incident occurred, and certainly I've seen the videos of the second set of shootings, that in all of the instances there was actually contact between the people leading up to the shooting incidents, and in all of the incidents there was some confrontative behavior, which is certainly subject to multiple interpretations, and I don't want to get into that. That's for the jury. But it's nothing like the incident involving the sister. So this, to me, is clearly propensity evidence. It's exactly the kind of evidence that the rule is designed to prohibit. And as I say, I'm virtually certain that if I admitted this kind of evidence, it would be end up in a reversal if there were a conviction. There's reference. You make reference to having a consistent motive. That kind of thing would be more persuasive if there were similar incidents in which there were demonstrated consistent motive. If the defendant would have gotten up on the top of the high school across the street, and every time a person who appeared to be a member of a disagreeing group walked by, take a shot at him, that kind of behavior would be a consistent motive, and would be very definitely admissible, but I don't see any connection here at all. So that request is denied. While I agree with you that you have the burden of proof, and you can't, and the defense cannot head off your evidence by saying we're going to acknowledge this was a willful shooting, I agree with you there. I also have to be open to the voice of reason in terms of how the case is shaping up, and I don't think there's any doubt about the fact that the defense is clearly conceding the issue, and the law is also clear that when that's the case, the judge has to look at it a little bit differently. Certainly if they walk in here on day of trial and start claiming that it was the acts of shooting were not willful, then I'll take another look at this evidence, although I certainly don't want to suggest to you that there might be a different ruling, but it would put a different light on it for sure. So that request is denied. The Proud Boys evidence, at this point I don't know, and perhaps you have other information which I don't know about, but I don't know whether there was a prearrangement to meet these people or if there was an awareness of who these people were. I have to tell you, I never heard of the Proud Boys before this case. And you cited a Seattle newspaper, and I'm not going to rely on a newspaper account about what an organization is, whether they're a hate-inspired group or whatever they may be. There's such a spectrum of groups in this country, and it seems to be more every day. But and I don't think it's for the courts, except in the most appropriate circumstances, to be making determinations, and certainly not on the basis of an article in a newspaper in Seattle, about what an organization is. But assuming that these people are a known group that is inclined towards violence, and particularly violence of a particular type, again directed against particular people, there's still no suggestion in the evidence that's been offered to me that this was anything other than a happenstance occurrence. And even if that isn't true, what the scope of the defendant's understanding was, and obviously it is an unfortunate fact that this case has become a surrogate for a lot of emotional reaction that has nothing to do, or little to do, or nothing to do with the issues in the case. But if this man is accused of these crimes, which could send him to prison for life, and he encounters some people who embrace him and start to, can we take pictures with you, and somehow make him feel better about himself, and he reacts by smiling with them and taking some pictures, for me to let that in as evidence of a motive that existed 4 months earlier, can't see it. Absolutely not. Again, I would expect to be reversed if I did that. I don't know anything about the hand gesture. That's another thing I never heard about before it came up in the context of this case. And I don't know about it, and I sit in the criminal courts all day long, and I deal with a lot of racially charged cases, believe me, and I never heard about this hand gesture, meaning having any, well, the first time I saw it, or a version of it, was Chef Boyardee on a can of spaghetti.
Your Honor, if I could just briefly
well, go ahead.
supplement.
Go ahead.
We're not alleging Chef Boyardee's a member of the Proud Boys, by the way. But two things. First of all, this was not a happenstance random meeting. In fact, according to a New Yorker article, which interviewed various...
Come on now.
Hold on. But they interviewed various people involved, and including members of the Rittenhouse family and their supporters. The defendant went to Miami on, I think, January 12th of this year and was picked up at the airport by the president of the National Proud Boys organization, who took him out to lunch. That was intentional. So this is consistent, this is a pattern, this is not a random meeting at Pudgy's Bar in
When
Racine.
was the event?
This was January 12th, so this was 9 days or 8 days after the incident at Pudgy's Bar in Racine. The defendant's in Miami, picked up at the airport by the head of the National Proud Boys organization. So I submit to you, the question the defense asks is, what's the proof that he's affiliated with his organization? This is the proof. He goes out after court, drives up to Racine and meets them at a bar, goes to Miami, is picked up at the airport, and has lunch with the national head of that. So this is the evidence of the affiliation.
What does that mean about August 25th of last year?
And the jury can make a decision on that, Your Honor. I believe that it is consistent with the Proud Boys' mantra, their philosophy of going to these types of protests armed with the intent of causing violence. And I think we will be prepared to introduce testimony from someone who is affiliated with the Proud Boys, and will tell the jury about their philosophy, will tell the jury what sort of violent activities they do at these incidents. So again, I understand the court doesn't want to rely on a Seattle newspaper article. We will have a witness who will tell the jury exactly what the Proud Boys is about, exactly what they try and do, exactly what their philosophy is, will identify the people in these meetings. Okay, so I understand the court may believe that because of the prejudicial nature of this, we're not going to introduce the evidence, but I want to button down those two issues. This was not a random chance meeting at Pudgy's pub because of the incident in Miami, and second of all, we will introduce evidence about the Proud Boys, far more than a newspaper article. So those issues, we can surmount those obstacles to the court's ruling, if that's what the court is concerned about.
All right, let's assume you're bringing in the evidence about the Proud Boys being in Kenosha on the day in question, and that they're here for their purposes. Is there any suggestion that they were connected in any way with the accused?
On the date of August 25th, I will acknowledge that I'm not going to be able to prove that that was a coordinated thing between the defendant and the Proud Boys that night. However, I believe there's a strong inference based on the fact that after court in January, he goes out to Pudgy's, goes down to Miami later that month, and meets with not only the head of the Wisconsin Proud Boys, but the head of the national Proud Boys. I think there's an inference to be drawn from that. Now, the jury can be instructed what weight to give it, but the defendant's actions of coming into our community illegally after curfew with a gun at the time of a protest is entirely consistent with what the Proud Boys make it their job to do. And then he meets with the leaders afterwards. To me, I think there's a reasonable inference that these are consistent motives all along.
Okay, and you've been in here enough, Mr. Krause has been in here enough to know that we get these pre-sentences where the defendant is accused of any number of things, and there's a section in there about gang membership. And I have stated probably 100 times, probably more than that I don't, I breeze right past that because I'm not interested in these accusations about group responsibility unless it's directly connected that the defendant is active in the criminal enterprises of the organization. Or, there's kids in neighborhoods right here in Kenosha who join gangs because they're afraid not to. Pope Benedict was a member of the Nazi youth because he had to be. This type of evidence is very dangerous. You make some points that might be legitimate. I certainly would keep the door open if you can show that there's any connection between the defendant on the day in question and this organization. But as I said before, if this organization embraces the defendant after the fact because he's lionized because of his behavior, that is not something that the jury can make anything out of that would be lawful. So, as I say, I'll keep the door open a small amount if you've got some evidence to suggest that there was some prior knowledge or awareness, but otherwise I think the evidence would be poisoned and would not be allowed. All right, now the next one is the defendant's first motion in limine, and that, well, there is a series of statements in there. Let's see. He's asking that the state be prohibited from the Pudgy's incident. That's in point 3, and I've already discussed that. The evidence that where the source of the funds with which Mr. Rittenhouse purchased the firearm is that he wants to prevent that from being offered. Is that any reason you want to offer that evidence?
Absolutely, Your Honor. The defendant is charged with illegally possessing a firearm. The circumstances under which he possessed that firearm are directly relevant to that charge. So how he obtained it, how he purchased it, the circumstances under which he purchased it, how he paid for it, etc., all of that is relevant. I believe that there will be testimony with regard to this. I don't think there's any dispute that the defendant turned around and used his stimulus check very shortly thereafter to go up to Ladysmith, Wisconsin with his good friend Dominic Black, and used essentially gave the money to Mr. Black, who then purchased it on behalf of the defendant because the defendant was 17. He can't legally purchase or own a firearm.
What is the source of the funds? How is that relevant?
It's relevant, Your Honor, because Mr. Black was working essentially as a straw purchaser here, Your Honor.
That's a separate issue. What he's asking and not be allowed is evidence about the fact that he used the stimulus money to buy the gun. Where's the probative value of that?
Well, Your Honor, I think it paints the picture for the jury of how this transaction occurred. How does Mr. Rittenhouse come into this money? It's a lot of money. We're not talking about $50 here. We're talking about $800 or thereabouts. So it's a large sum of money. Mr.
Actually,
Rittenhouse,
you're providing the explanation. I would think that you'd want to offer that. Where did he get this money? I don't understand.
We can leave the question open for the jury, Your Honor, and we can let them try and speculate if they want to. But since we already know the answer, why not tell them the truth?
Why tell them anything? I mean, he had money. He apparently had a job as a lifeguard or something, I read.
I don't know that he had that job at that particular time, Your Honor. No.
I don't want to get into
I mean, the defense is going to talk about his work as a lifeguard. We've already heard reference to him, working in our community, although he worked in Pleasant Prairie. But
what is the relevance of the stimulus money being used for that as opposed to being used for drugs or for new musical instrument or a boombox, or is it? I don't know.
If we want to cut off reference to that,
is that a current term, boombox? I don't know.
If we want to cut off reference to that, Your Honor, then why don't we just cut off reference to the defendant working in Pleasant Prairie as a lifeguard too?
You haven't given me a reason.
Well, I think it's the same issue. I think it's the same. It's two sides of the same coin, Your Honor.
Yeah, I would tell you that I don't think it's a big deal, but I do think the defense is correct that it doesn't sound to have much relevance. I also don't. You're suggesting that the reason he's trying to do it is to denigrate the defendant for not using the stimulus money for a more altruistic purpose. I would imagine that some percentage of the American people who got money used it for altruistic purposes, but I would bet most didn't, including some who probably spent it on illegal drugs.
I just don't see how it goes to any element that's in dispute here. I mean, it's just, I think it is to denigrate him, to try and paint him bad, and that's why they put it in the Washington Post article. I believe that's where it was got, or the New York
Post article. I did, by the way, read that New Yorker magazine article that you mentioned, but I didn't read.
I don't think it's an issue of denigrating or making him look positive. The stimulus money was intended to stimulate our economy. It was designed to be spent at various locations. Whether you go out and you buy groceries, or you spend it on your rent, or you buy a gun, it certainly benefited the Ace Hardware and Ladysmith to sell that gun. There's nothing wrong with that. Gun ownership is legal in our country. Dominic Black purchased the gun. He's legally able to do that. Of course, the defendant isn't, but there's no implication here by the fact that it's stimulus money used to purchase a gun. There's no automatic implication, positive or negative, on that. It's exactly what the stimulus money was intended to do, was to be used to stimulate our economy by supporting businesses.
Yeah, I think it's going to elongate the trial. So to me, it's, I'm not going to give you a definitive ruling now, because it's not, in my estimation, it's not that objectionable, but it's also not that probative. And I tell you what, we're not going to spend as much time at the trial as we are today talking about this, because we want to move this case along. So if he asks and you object, you're going to get a one-word response as to whether I decide at that given moment in time whether it's, and that may have something to do with the pace at which we're moving. So I just don't want to get bogged down. The item number 3B, that's Pudgy's again.
Your Honor, I think 1 and 3 in the motion in limine are covered by your ruling on the other acts motion, so I don't know that we need to spend more time on it.
Judge, I think it's everything then. I think this was filed before the state filed their other acts motion.
All right.
So it was kind of done preemptively.
So we're all done with this?
We are.
Yeah.
Motion to admit evidence. That is evidence of whether, because Joseph Rosenbaum had been convicted of child sex offense and went to prison for it, I guess three different times. You can start talking with an extreme bias towards denying your request.
Understood, Your Honor.
Okay.
Your Honor, his status as a felony offender is relevant in this case because based upon the facts of that evening and his conduct. When Mr. Rosenbaum was on the scene on the 25th, he made threats to numerous people, including my client and Mr. Balch, where he specifically said, if I get you alone, I'm going to kill you. And that happened earlier in the evening. It's reported. I received that in discovery from the government. It was from an FBI agent who interviewed Mr. Balch. Mr. Rosenbaum made other threats about not being afraid to go back to jail. He stated, I just got out that day, which was overheard by my client. And ultimately what ends up happening, and it's on the video, my client is walking down the street, Sheridan Road, towards what I would refer to as car source 3, where the first shooting occurs. As he's walking down that road, Mr. Rosenbaum becomes aware of Kyle. He's been called and asked to go there to potentially put out fires that people are starting at that location. He asks for...
You say you're talking about
my
the
client.
accused. Okay, go ahead.
He asks for a fire extinguisher from the gas station at the corner of 60th and Sheridan Road. Somebody provides him a fire extinguisher. He takes off in the direction of 63rd and Sheridan Road, car source number 3. As he's going to that location, Mr. Rosenbaum and Mr. Zeminski are seen on video behind him. And in front of him. My client starts off behind him, goes past them. As my client passes Mr. Rosenbaum has his face covered with his shirt in a ninja type mask, not a COVID mask. It has over the top of his head and a slit for his eyes, hiding his identity. As my client goes by him, there's statements of get him, kill him, things like that. Whatever is said, it's in dispute, but there's something clearly said. As my client is aware that he is being chased, he's also being followed by a reporter by the name of Richard McGinnis. As he's being chased, McGinnis follows him. My client runs into the lot of car source 3. Right before he enters the lot, he's being chased. He drops the fire extinguisher so that he can get away faster, I would submit. As he gets into the middle of the car source 3 lot, Mr. Rosenbaum continues to follow, chasing him. He throws something at him, which has now been determined to be a metallic type bag. You see it clearly in the video. Mr. Rosenbaum fires it at my client. There's evidence that there was something in that bag that was removed before it's recovered by police, also from a statement from, I believe it's Mr. Balch. My client turns around, addresses Mr. Rosenbaum, still being followed by Rosenbaum chased and Richard McGinnis off to the side. He turns around when Mr. Rosenbaum does not stop, even though he's pointed a firearm in his direction, and begins running away further, and he's looking over his shoulder back at Mr. Rosenbaum, who continues to advance. Richard McGinnis states that Mr. Rosenbaum continues to run at Kyle, even though Kyle is now addressing him and pointing a firearm in his direction. Mr. McGinnis states that he lets out, as he describes it, a blood-curdling scream yelling the F word.
He being?
Mr. Rosenbaum.
Go ahead.
My client, as he's jumping towards him, fires the 4 shots, which take less than 1 second, hitting Mr. Rosenbaum. Your Honor, Mr. Rosenbaum had the will, he had the intent, and he had stated what his motive was, to take somebody who he believed is a threat, who would put out fires that he had been starting, had been stopping them from burning down buildings, and now was his chance. Mr. Rosenbaum, because of his status as a convicted felon, is unable to lawfully possess a firearm, could not purchase a firearm. He saw this as the opportunity to possess a firearm and take care of what he believed was a threat or a problem to the rioters, not demonstrators, rioters, which Mr. Rosenbaum was. There's numerous photos earlier of Mr. Rosenbaum wearing a shirt in a proper fashion over his body, not using it as a mask. In the state of Wisconsin, hiding your identity to commit a crime is in itself a crime. he was doing that. Your Honor, the case that I've cited in the brief, State v. Ingram 204 with 2nd 177, and it's also cited in the annotations for the witty cautionary instruction. And I know the court knows that it's your case. It's the fleeing and the looting, and the state sought to put in the fact that he was convicted. In this case, it is our argument that he was trying to take the gun, one, because it was readily available, two, he could not legally purchase one. Many of the individuals that evening on both sides of this were heavily armed. There's Black Lives Matter individuals with guns. There's people who are protecting property with guns. There's militia members parading around. It's our position that Mr. Rosenbaum could not legally possess a gun, but that wasn't going to stop or deter him. And, you know, I read the newspapers, I read the stuff, and everybody's, oh, he just wants to put that in to sully the victim. One, it hasn't been determined.
To sully the victim? Okay, go ahead.
One, it hasn't been determined whether he's a victim or whether this was a justified homicide on the part of my client. Secondly, under Old Chief versus U.S. 204, United States 177, there could be stipulations that could be entered into. In this case, it doesn't have to be that he's a convicted pedophile. It can be that he was a convicted felon, which serves a purpose. He was stealing a firearm while masked, attempting to, which is a felony in the state of Wisconsin. Theft of a firearm, masked, felon in possession of a firearm are just a list, not to mention attempted battery, things like that, that he was attempting to do that evening to my client before he was shot. It's highly probative. It explains why Mr. Rosenbaum possibly didn't bring his own gun, why he was seeking to get the gun from my client. And that isn't my client's words. My client would testify to that, but it's an independent witness who the government has listed as a complaining witness, Richard McGinnis, who says he was going for Kyle's gun. And that's in interviews to law enforcement, and that's in interviews to my investigator.
Did you say when you began that there's a witness who reported hearing Mr. Rosenbaum say he just got out of jail that day to the accused?
Yes. He said he was announcing it to the people at Car Source 2 where my client was in the property. And it wasn't jail. He had gotten out of a mental institution, but it was the evidence, I think.
Well, what the institution he was in was not important. What the what the decedent allegedly said is the important thing. He allegedly said what?
He said, words to the effect, I just got out of jail today, I'm not afraid to go back. And
is that in the discovery, I assume?
I don't remember those words. I know he had gotten out of, I think it was a commitment that day, not jail, but I don't recall seeing those words.
Go ahead, I interrupted you.
Hey, Your Honor, that's the argument. He said it. It's in the discovery, which I was provided by the state. It's reported by numerous individuals, and you know, there's that incident. There's where he's yelling to people, "Just shoot me, N-word." He was not a demonstrator. He was somebody who came to Kenosha, whether he lived here or he didn't, came to the downtown area to wreak havoc on the city. And our position is he ended up attacking our client because our client was alone, and our client ran from him as far as he could. And in the drone footage, you see him run up against a wall of cars. He stopped at that location, and he can't go any further. On the other side of the cars, from the drone footage, you see the demonstrators bashing in the car windows, and he didn't want to run through that. He turns around, he addresses Mr. Rosenbaum. After Mr. Rosenbaum's buddy, Mr. Zeminski's already fired the first shot within seconds of Kyle firing.
Mr. Binger.
Judge, there are a lot of people out there commenting on this case that are happy that Kyle Rittenhouse killed a pedophile. And that's the danger here. We don't want the jury to make a determination that somehow this was justified because it got one child molester off the streets. That is not what was going on here. I want to clarify that Kyle Rittenhouse knew none of this at the time of this incident, had no idea that Joseph Rosenbaum had ever been convicted of a felon, had no idea he was a sex offender or anything like that. So this doesn't go to Kyle Rittenhouse's state of mind. And that's important for self-defense. This is not a subjective issue. This is not a reasonable issue. It does not go to self-defense at all because there's no evidence Kyle Rittenhouse knew anything about Joseph Rosenbaum's history that night. They had never crossed paths before that night. They'd never met.
And I agree with you on all of those points that you're making. I guess I'm struggling with, and as you recall, I started by saying that I had extreme bias against the defense position. But I'm struggling now a little bit because I'm hearing about this statement allegedly made by Mr. Rosenbaum about having just gotten out that day and not afraid to go back, if that is in fact testimony that's going to be offered at the trial. It does put a different light on it, not about whether he's... I would be surprised if I would admit evidence that he was a sex offender or that he had the number of times he had gone to prison or the revocations. However, if indeed there's evidence produced that he had made the statement about just having gotten out that day, that certainly does put a little bit of a different light about it. So you don't have to convince me that about what was in the mind of the accused, other than the statement allegedly made that he had just gotten out that day. And so why don't you argue on that point?
Sure, Your Honor. With regard to the motive that Joseph Rosenbaum had that evening when he confronted the defendant, because that's where this really goes to. The defense wants to argue that his motivation in confronting the defendant was, among many other things, which counsel's just detailed, a desire to obtain the defendant's gun because Mr. Rosenbaum couldn't get the gun any legal way. That is really what this is. He's a felon, so he can't go to Dunham's or Gander Mountain and buy a gun. He's got to steal it. That's the only reason why this fact of his felony conviction could possibly come in at trial, is to show that motive. So, how plausible is that motive? First of all, we have no evidence that Joseph Rosenbaum wanted a gun that night. None whatsoever. No one is going to testify that he ever tried to get a gun since his last felony conviction, that he ever said he wanted a gun that night, that he ever said anything about wanting to get armed that night. There is nothing in this record as to him saying anything about his motivations with regard to a gun. Second of all, counsel's acknowledged everybody had guns that night. In fact, earlier in this hearing, counsel referenced a racist statement that Mr. Rosenbaum said. That is on video. Everybody's seen it here in the court. And it's clear Mr. Rosenbaum is walking up to individuals that are similarly armed to Mr. Rittenhouse, that are openly carrying AR-15 style assault rifles slung around their shoulders. He gets in their face and he is challenging them. This happens on the videos. Now, does Mr. Rosenbaum at any point reach for anyone's gun in that situation? No. Does he try and take it away from anyone? Does he say, let me have that gun? Does he say anything about a gun? No. So I posit, Your Honor, that if Mr. Rosenbaum showed up randomly in Kenosha that night, after having been released, and decided, this is the night of all nights, I need to go get myself a gun because I can't buy it at the store. If he really wanted to steal it, he had the entire evening to steal it from countless people. But he wasn't chasing after Mr. Rittenhouse because he wanted to steal Mr. Rittenhouse's gun. Counsel's already detailed numerous allegations or parts of this story that the defense will try and introduce evidence on that suggests that there were other reasons why Mr. Rosenbaum may or may not have been chasing Mr. Rittenhouse. And by the way, I don't concede the narrative that counsel laid out about the facts here because I think there's more to the story, which we'll get at trial. But at any rate, if you listen to counsel's argument, the allegation is that Mr. Rosenbaum was starting fires. He was trying to destroy property. The defendant was grabbing a fire extinguisher, trying to stop Mr. Rosenbaum. They had multiple interactions, at least one at the car source on 59th, and then maybe later on as they're traveling down Sheridan towards the 63rd Street car source. At any rate, those are all potential explanations why Mr. Rosenbaum may have had a motive to do what he did that night. And they are far more relevant in time, plausible, and consistent with the evidence than this obscure notion, this implausible and irrational notion, this unreasonable notion that Mr. Rosenbaum decided this was the night that I need to go get myself a gun illegally on the street, and that's the person I'm going to take it from. I mean, Mr. Rosenbaum, to say that the best way for him to go get a gun that night is to approach an openly armed individual carrying an assault rifle slung around his shoulder and take it from him by force, it strains credibility, Your Honor. Now, in their motion, the defense has suggested that there's some evidence Mr. Rosenbaum was reaching for Mr. Rittenhouse's gun. Now, they didn't mention that here in the hearing, but it's in their motion. Well, let's talk about the circumstances of that interaction. Yes, it is on video that at some point Mr. Rosenbaum is running through the 63rd Street car source, chasing after Mr. Rittenhouse. He throws a plastic bag. It's not a metallic bag. It's a plastic bag. Towards Mr. Rittenhouse, which lands harmlessly 10 feet behind Mr. Rittenhouse as they're running.
I've read that over and over again about the plastic bag being thrown at somebody. Now, if I throw a plastic bag at you, I guarantee it's not going to hit you. And that would be true if you're standing 2 feet ahead of me. So I guess I'm interested in what the images show about the course of the plastic bag. I mean, did it just project a foot and then drop to the ground? Or
No.
did it act like a missile in the direction of the accused?
There was something inside the plastic
There was
bag.
something inside of it.
We've
Okay.
never been able to determine exactly what it was because it was not recovered in evidence. This was a scene where, obviously, because of all of the chaos and situation,
The point is that it's shown on video.
it flies
This
into
is
the
not
air.
just a plastic bag, which is what the complaint says, a plastic bag.
Sure. It flies into the air. It lands about 10 feet behind the defendant as the defendant is running away. I don't think anyone can reasonably argue that it was a risk to cause bodily harm at any level to the defendant. I suspect Mr. Rosenbaum threw it out of frustration or anger, but it's not a reasonable threat to the defendant's
My
safety.
question has been answered.
Okay. So then what happens is these individuals run between some parked cars, and there's an allegation in the defense motion that Mr. Rosenbaum is reaching towards the defendant's gun, may have come into contact with the gun, although there's no physical evidence to support that. But at any rate, why is Mr. Rosenbaum allegedly doing that? We don't know. We don't have any statements from him. We have speculation from witnesses. We can speculate by watching the video, but that is all that is pure speculation. Now, I submit that in that circumstance, the most reasonable explanation why Mr. Rosenbaum may have been doing that is the same thing any of us would do if someone pulled a gun on us, is probably try and defend ourselves by pushing the gun away or knocking it away or anything like that. But the notion that in that moment he thought to himself, I'm a felon, I can't go to the store and buy a gun, so I'm going to take it away from this random individual on the street, is utterly preposterous, Your Honor. So I don't think there's any plausibility here. I don't think there's any evidence as to the Sullivan factors of motive, intent, knowledge, anything along those lines here, because we simply don't know. And Mr. Rosenbaum, obviously, is not in a position to answer any of these questions because he's deceased. So we're talking about the motives of someone who can't defend themselves, can't respond to any of this, and that is completely improper.
Your Honor, just briefly in response to some of the more interesting points Mr. Binger made. One, the evidence is timely. It's part of what happened that evening. Two, Mr. Binger talks about there were other incidences where he was with individuals going at them who were armed with AR-15s. The very distinctive thing between those incidents at the gas station on 60th and Sheridan Road and the situation between my client and Mr. Rosenbaum are, my client was alone, it was not well lit. At the gas station where Mr. Rosenbaum is going nuts, yelling, shoot me in, repeatedly, he has to be held back from those individuals with guns. And there are numerous individuals. It's no individual standing alone, he's going at them. The threat regarding I just got out of jail and I'm not afraid to go back was earlier in the evening at Car Source 2. The bag incident the state can talk about it not being or meaning anything. It was a metallic bag. You can clearly see it fly through the air, lit up from the lights that were in that area. And the client will testify that he had seen Mr. Rosenbaum, this is on video, right in front of car source number 2, walking down the road with a huge chain that had been taken off a trailer that Mr. Rosenbaum and other individuals had threatened. So he knows he has something metallic. And he talks about Mr. Rosenbaum defending himself and it being rational. Your Honor, it's not rational to chase somebody unarmed with a firearm. But he chose to do that. And he lives or dies with the consequences. In this case, he died with the consequences, trying to take a firearm from an armed individual. And we can say, the state can say it's speculation, and I can say it's not speculation. He wanted a firearm. That's why he was masked, and that's why he attacked someone who was by themselves, who was on the other side.
Well, I certainly you're welcome to pursue the evidence and attempt to prove that the decedent was attempting to take the gun from the accused. But I think that he was that there are a universe of motivations that Mr. Rosenbaum could have had, and to invite the jury to speculate that it was because he couldn't legally acquire one, that's too much for me. So I'm gonna grant the. I guess it comes in here as a request on your part to admit that evidence, and I'm going to deny that request. Notice of intent to introduce. Oh, this is the testimony of John R. Black. By the way, the clerk told me that there were some materials received today about expert witnesses that I have not seen. They were not filed until either this morning or last night. Yesterday afternoon, and I haven't seen them, and I hope they're not something that you expected me to talk about today, because I've not even seen them. But I do have the discussion regarding John Black, and I will tell you before I hear what you have to say.
Your Honor, before we go any further, can we just take like a 5-minute break?
Your wish is my command. All right, let's start again at 25 after.
Thank you.
I think I've got a case waiting in the wings, don't I? Who does? Okay. Yes.
I'm just simply window
Okay. I was actually at one. Well, never mind. I was going to try to cover my tracks now, but. No, get rid of it.
Good.
What's on the 11th? What is the 11:30?
Probation violation.
Let me take a look.
You may reschedule the 11:30.
Beach. Oh, that's Joseph Beach. Okay. This is a request for additional time, so I really should hear that. Let's hear that right away when we get back. What's it set for 11:30?
Yes.
Well, let's see if we can move it up. One today? I already have this.
sharp today. I'm so used to seeing you in
Flip-flops and
other attire.
see, I set the bar real low. So then I show up like wearing a cheap, not well-fitting suit. That's like way up here.
You outdone yourself.
Left to a trial. I think I had height pretty similar to that. We'll have to not coordinate. My
Do you have pocket squares as well?
no, I'm not nearly as fashionable as Tom. Nor do I have the lapel pin. I actually was given a set of lapel pins and cufflinks when I graduated from undergrad from my then girlfriend's parents. And the store never shipped them. So then I was left in this weird position. He'd already broken up. It was kind of a strange situation. So I was like, hey, you know.
It's like a Larry David career.
It's one of those things where it's like, you know, I got 3 months left of undergrad. We'll just stay together and then we'll just try to go our separate ways. And yeah, they've got these really nice cufflinks and, you know.
I have nothing like the home doesn't match, but the only reason I know that is because my dad bought me one too. And it's a very big cigarette. That's why now when all his buddies came back, everybody got married. So my dad was 61.
Ah.
It's kind of a standard thing that we give a tie class as a cufflinks as a gift. So my dad has 5 or 6 sets of them. So I wear this one, which is like a pair of clothing shop or something. I don't know. Anyway, I think it's cool. But I don't have any shirts that.
I guess I wouldn't do the cufflinks. I think I wore. I think for a wedding I had the French cufflinks ones. But yeah.
Or a monogram.
No, I'm not fashionable. By day 3 of this trial, I'll probably be back in flip-flops.
Cycle through your repertoire.
Yeah.
Well, I did a 17-day jury trial in Sheboygan, and I was able to not replicate a single outfit. So duplicates.
Well, that was easier. Well, I heard it's easier, more difficult.
I feel like you could just wear a white suit and different tie, or white just shirt.
Yeah, I guess that's
tie,
the thing.
So as long as you have 17 ties.
Which I do. I mean, finally, we are actually not stained or torn. My wife is an University of Illinois grad, so that's why she looks in the Illinois colors as a joke.
Yes.
She was in our. She went to lunch with Angie, Georgia Gabrielle, a couple weeks ago, and she's like, "Who's in my spot? Whose license plate is Double Badger?" And I was like, "It's like a half marathon," so I assumed that was you.
Yes.
And she was angered by that.
So I took her
I agree with
spot.
that.
No, that there was Double Badger. And we're on the exact opposite of every
Sports team
sports.
affiliation.
Yeah. Brewers, Cubs, Bears, Packers. We don't really care about the NBA. I mean, I did this summer as a bandwagon fan, but Wisconsin, Illinois, which they're not really rivals, but you know. And then so. But she likes to get an Illini colored things in the gym.
Scratching.
Which is weird because, like, you know, we know everyone's car. So then, like, when there's a different car there, when you go to the receptionist is parked there, I assume that it's someone parking there. Because people do, like, to see a spot parked there.
Right.
And, like, once in a while, somebody can do potentially
That's awesome.
So, like, yeah, it's real. But,
Yeah, they
What do you got about it?
Sheboygan canceled the jury trial because of the parking. And the lot was full because it was jury selection. So she just like, it's like, I'm
that's the
fine.
trial. Couldn't you, like, tow the car?
That would have taken 2 years.
Yeah. I find it funny that these judges here, some of the judges got closer parking spots. We're talking about like 10 feet closer. I didn't sure Rittenhouse was on Tucky for half the year. He hurt himself. That might make some sense. I noticed that there was some spots there. I really. Now you're walking the roads 30 feet, not 50 feet. Is it
Right.
really?
Is it really worth it?
I guess it was minus 50.
Did you see that?
Oh, really?
Mm-hmm.
I did thank Mark for asking for one.
Seated, please. Well, yeah, let's do that. We're going to take one short case. Physically bring him in?
No.
Oh, into the Zoom? Okay.
This week?
That's why I stuck around.
Oh, you weren't here to watch my performance.
We're not that interesting.
But you're gonna have to log in because I don't know who's on.
Okay. Let's see. All right, he's not in the room yet. Okay.
Yeah, no problem.
Jail administration.
Well, there he is.
All right. Oh, he's in. Oh, that's Mr. Thompson, I think, in Racine.
Oh, I told them that we were.
Mr. Thompson and Racine, yeah, that we're going to have to adjourn that case because I'm occupied with another case, and Mr. Prosecutor is not able to. Yeah, he's with Judge Repeshek, so we're going to have to reschedule Mr. Thompson's case. So I apologize, Mr. Thompson, to you and to your lawyer. We will do, however, the case in Kenosha of the state against Joseph Beach, and. Let's see, we've got the Assistant Attorney Alexandra Smathers here in the court, and I don't believe Mr. Yeah, but I don't think he has a lawyer. Do you have? Oh, here we are. Attorney Liebem is here on behalf of the defendant, and it is here on a probation review of the Department of Corrections. I don't think the agent is on the line. That didn't work. Okay, I tried to increase his size, and that didn't work. Okay, in fact, no, I can't find him at all. I hope he's not. Oh, here he is. Mr. Beach there's a request to order an additional disciplinary confinement on his probation. He's had two prior custody periods, one in May and one in July and August, for violating the no contact order for the victim and consuming alcohol. And agent reports just 3 days following his release, Mr. Beach was arrested on 8/23 for again violating his no contact order with the victim in these cases and for consumption of alcohol. Did you want to comment on that at all, Ms. Smathers?
No, Your Honor.
Ms. Labum?
Just briefly, Your Honor, Mr. Beach obviously was here prior for a no conduct order violation. As he explained then, the victim did reach out to him. He was not attempting to have contact with her at that time. In this particular instance, when Mr. Beach was released from custody last time, he did not have anywhere to stay and was set up to stay with a mutual friend of the victim. They had gone out that night and the victim was there. Mr. Beach understands, though, that whether or not she wants contact or whether he wants contact, he understands that obviously he cannot keep violating the conditions of probation. As stated in the agent's letter, he had previously worked to try to get that no contact order lifted, but understands that the department does not feel that that is appropriate at this time. The only reason that he did have contact with the cops that night was because they were both helping their mutual friend back into his apartment, who's handicapped, and someone had called the cops because they were being loud. But there were no new charges, and he has been trying to keep in contact with his agent while he was released, and is, willing to do any programming or treatment that his agent does find necessary. He's been working with Eddie Hartnell and KCDC to connect him to these services when he's released, so he does have somewhere to stay and does have other resources in the community, so he does not have to keep having contact with the victim. This has been a huge wake-up call for him, and he understands the seriousness of these violations, and we're asking for no additional jail time. Thank you.
Thank you. What's the history prior to this case, Ms. Smathers?
I'll pull it up, Your Honor, and just to note, the probation agent is now present. Yeah, I do know he has a significant history, much of which is out of state. As for Kenosha, he's on probation for this false imprisonment, domestic violence, strangulation, suffocation, domestic violence. The rest is all out of state. It's detailed in the PSI, which I'm pulling up right now. Uh, 2020 possession of drug paraphernalia out of Windbrook Harbor, Illinois. 2007 unauthorized use of animal/vehicle/ETC larceny out of Suffolk, Virginia. 2003 entering property of another with intent to damage, also out of Virginia. Also 2003 breaking and entering grand larceny, also out of Virginia.
All right, did you want to add anything, Ms. Starr?
We don't have a specific recommendation with regards to conditional time, but we do feel that it would be appropriate considering the ongoing lack of cooperation with regards to his supervision and with the contact with the victim, despite knowing that he's not supposed to, and then given also his history of behavior when under the influence and committing offenses. We would like for the court to take that into consideration.
Thank you. Did you want to say anything, Mr. Beach?
I now understand that I messed up a lot of times in a short amount of period of time. I have, in the past, such as the last time, I was just, I didn't have really any stability, and Tracy the victim was trying to help me, and we both understood that we shouldn't have been there with each other. But we were trying to get our relationship resolved and everything, but I do understand that this is a big wake-up call, considering the fact that I don't want to keep on living this jail life, especially over something I can take control of, and hopefully with the courts or with my probation officer, eventually it's time to get it lifted, upon, on her standards. I'm done seeing the victim. And I know I've said this many times, time, but this is a big wake-up call for me. I just want to get my life in order. I know I have an alcohol problem.
The alcoholics know it. You're responsible for your behavior. I don't want to hear about the alcohol. That's totally under your control, sir. I don't care what anybody else tells you. It's under your control.
I know.
You don't like the jail life? Stop committing violations of the court's orders. Those orders were put in place. We don't put them on everybody. We put them on you because you were slapping a woman around. You've got a criminal history, and you're now adding up enough time on disciplinary that the next step for probation may be revocation, and then you'll risk going to prison. So you'd better shape up accordingly and do exactly what is expected of you, and stop if the alcohol is causing, you're not supposed to drink. That's probably a condition by the department, and I will enforce it if you violate that. So no more episodes. You're to be confined in the county jail until the 21st of December. I think that's November. I think that's a total of 90 days from the day of his arrest. A number of days until the 21st of November. Anything else?
No, thank you.
May I ask a question?
Go ahead. No, you can't have contact.
I know. I was just wondering, is this the additional jail time that you're giving me? And
It is, because you haven't done what you were told to do.
Okay, and just one more thing. Am I being what you call revocated, or?
No, you're not being revoked right now, but you're cruising that way because you're using up all your disciplinary time. So stop violating. I put you on probation.
Yes, sir.
I put you on probation because you were going to do better, and I'm not seeing it. So do what you were committed to doing, and then you'll avoid having to make further visits to see me. Anything else?
I promise, Your Honor. And upon November, whenever I get released, what happens after I get released?
Talk with Ms. Starr. Just do what you're told, and you won't have any problems. I've got to go, sir. I've got another case going. Thanks, Mr. Beach. Would you tell the officer your hearing is over, please? One more. Go ahead, one more.
I just don't know how to get a hold of Ms. Starr while I'm incarcerated.
She'll get in touch with you.
Okay.
Thank you, Mr. Beach.
Thank you.
Have a great day. What?
You too.
Strangulation. All right. Apologize. We're back, and I think the last thing was, this state's witness list. And I have to say, when I saw it, it did bring to mind the very case that the defense cited, State against Irby, when the discovery first came in. And I'm old enough that I remember when they changed the law, and the prosecutor made a heavy list on the accused of every name in the community or something, and the Supreme Court says you can't do that. So I don't want to take too much time on this. Have you narrowed down this 175 witness list?
Judge, we were on the motion with Mr. Black.
Oh, we were, but now that I'm talking about this,
and then we skipped a couple extra.
We did, and we'll come back on Mr. Black. I must have turned my page when I took the break. Yeah, but let's talk about the 175 witnesses. Has that been slimmed down?
Yes, so Attorney Binger did send the numbers of individuals that we are more likely to call.
Okay.
That, of course, may change as we get closer to trial, but we have narrowed it down in private, of course. We do want to be more expansive on our list, just in case something comes up that was unanticipated, and that way there's not a dispute at trial that a witness was not listed. But we have
privately narrowed it.
Satisfactorily?
On one aspect. They put it down to, I believe, if I counted correctly, 27 witnesses. Okay, and I can live with that, but they have not provided addresses.
Well, wait a minute now. That I noticed that they claim that they would provide them to you so they didn't get posted on the internet. And did you say, okay, we'll take that, or did you?
I was told by Mr. Binger they're in discovery, find them. And
is that true?
I emailed Mr. Richards yesterday. I gave him a narrowed down list. I said the addresses that we would be providing to him would require us to go through the same 400 plus pages of police reports.
What does the statute say?
The statute does require us to provide addresses in a written filing with the court.
So I can expect that'll be done by Monday at 5.
Would you like us to file with the court?
I understand your desire to keep it from being filed, and I think that if the defense objects, we'll have a discussion about it. But no, you can do what you did, but you need to send him the addresses.
And
by 5 o'clock on Monday.
My biggest concern is updated. This has been 13 months ago. People move, things like that, and obviously they're going to have the most up-to-date addresses to get people under subpoena and things like that.
Okay, so that's done. Now we were talking about expert witnesses. Now let me just say that my last acquaintanceship with this issue was that and this is a little bit different, some of the issues that are discussed. But ultimately what this witness is being called for, Mr. Black. Dr. Black, what is it? Dr. Black. What Dr. Black, what the defense proposes to bring Dr. Black in is ultimately to show that the defendant's conduct conformed to the law of self-defense.
It's more what I would characterize as use of force. And one of the things that we've been addressing, it was said earlier in this, is how he handled his firearm that evening. Whether what he did with his firearm was reasonable. His reaction times to being attacked by Mr. Rosenbaum. He also has the ability through his software to break down every incident frame by frame, which allows him to put very accurate timelines on each of the shooting aspects. One of the things that I'm sure the state is going to...
You know what, I'm going to interrupt you right now, because I think we need to have a full-fledged Daubert hearing on this. And I need to see the report. That would be on page 1, is I have not seen the report. What is it, 28 pages? I haven't seen it. I don't know what it says. And I'll have a better understanding of what you propose to prove. Certainly the law is that when it comes to use of force, when it comes to use of force, I'm the expert. Not because I'm so bright, but because the Supreme Court says I'm the expert, and I'm the only one who's going to be defining what is reasonable under the law. What constitutes self-defense. So I'm not going to have competition in the courtroom, so we're not going to have any evidence on that subject. On the other hand, just as in sexual assault cases, state brings in witnesses to prove a variety of things from people who are experienced in the field. So this use of force may have kernels that would be admissible, and I won't know that until I see the report and have the hearing. So before we leave, we'll have a Daubert hearing set. So do we need to take this up other than that today?
Is the court intending to hold that hearing prior to trial?
I do. And then the materials that were filed yesterday afternoon, do they pertain to expert witnesses also?
They're notices of experts.
Oh,
There are
Three of which were already on the witness list and then already have the reports.
Okay. Okay.
We have the reports.
Is there going to be an issue with respect to them?
As to them, no. The third one, I believe, is self-defense use of force expert.
I didn't hear the last thing you said.
Self-defense use of force expert,
Okay.
much like Dr. Black.
State's got one too?
Yes.
Okay. All right. Well, we'll have a common Daubert hearing for them.
And Your Honor, we don't plan on calling ours obviously if the court grants our motion to exclude Dr. Black's testimony, then we won't need our witness either, but we have to plan for the contingency if the court rules otherwise.
Okay. Next. Motion to compel discovery about donation lists, and is this still an issue?
It is.
Okay. Now, the defense statement by Mr. Richards that I read was that he doesn't have any access to any information from Free Kyle USA. And are you disputing that?
It's run by the defendant's mother, so yes, I am.
It is.
The defendant's mother is not a party to this action.
Well, the defendant's mother is someone who the defendant can obtain information from quite easily.
Legally?
Your Honor, this is not a third party. This is not an accountant.
It is a third party.
It's his mother, Your Honor. I submit that it's a reasonable request of the defendant. He's the beneficiary of all of that fundraising. He is the person. It is called Free Kyle USA. He's Kyle. So this is not an independent entity. This is something that they have the ability to access. And Your Honor, quite honestly, if the shoe were on the other foot and there was some sort of fundraising for the state in this prosecution and we didn't turn that information over, it would be per se a reversible error. So we're entitled to the same... I'm telling you,
by what authority can I order a citizen to provide, that you can subpoena, by the way, to provide material to the defense attorney or to the defendant that is her proprietary information and command them to cough it up? The law is I can make them produce what they have. I cannot compel them to produce something, nor do I know of any authority that I can make her give it to them. Is the law different from what I've stated?
Your Honor, will you issue, if the state supplies you with a subpoena, will you issue a subpoena then?
I'm not going to give an advisory statement. I'm going to tell you that I do not think I have the legal authority to compel the defendant to procure information from somebody else who owns it and provide it to you or to the court even. I don't think I have that authority. Now, whether it can be subpoenaed, and you ask me to sign the subpoena, can't you do that?
We will
The defense can't do that. They need my approval. You can subpoena on your own signature.
The entity may be located in a different jurisdiction, so we may need this court to authorize it. So that's why I asked,
maybe we should we'll just talk about it a little bit then, if this is something that's going to come up. No, I'm not going to talk about it a little bit. I'll save that for another day if we need to. Then you also ask for the Fight Back Foundation, and you want a list of their donors. Do you have that?
No. Your Honor,
same issue.
And Fight Back is represented. It's run by Linwood and a board. We separated from them in late December 2020, early January 2021. I tried to get the exact date, but I received two different answers, so I don't want to give a specific date. However, there is no contact with that organization anymore. I know that at one point, some of the civil lawyers involved in this sought to seek that information because they believe there hasn't been a full accounting for the funds that were given. There is no communication or cooperation. I believe Fight Back is in Texas, incorporated in Texas. I don't have it. I've never had it. I've never requested it.
Same issue.
Understood.
Okay, then I'm going to pass on that. Well, I'll deny the motion at this point. State's second motion to omit other acts evidence, reporting about an incident that is claimed to have occurred on the 10th of August involving an incident outside of CVS.
Your Honor, there's no dispute the incident occurred. The defense motion has acknowledged that the defendant was there, that it's his words, that he essentially made a statement that he wished he had the same rifle that was used in this incident to kill 2 people so he could shoot individuals coming out of the CVS pharmacy. This is 15 days prior to the August 25th incident, so it's very close in time. And it again goes to the issues we talked about earlier. This is a continuing motivation here. The defendant is irresponsibly using his firearm, or threatening to use it, I should say, talking about using it to shoot individuals who he believes are ostensibly committing a shoplifting offense from CVS in Chicago. He has no ties to the business. He has no role to play there whatsoever, but yet he wants to launch himself into the middle of it with this same gun. And it's similar to what we have on August 25th, Your Honor, where the defendant is in our community with that same gun and using it in a manner that I think is legally unjustified. So this goes exactly to his state of mind in terms of his understanding of use of force, his understanding of self-defense. Self-defense of property by use of deadly force is not allowed, and that's very clear. So this is a completely unjustified use of a weapon. It's the exact same weapon that we're talking about here. So for all those reasons, Your Honor, I believe that this is admissible other acts evidence. I think it goes to his state of mind, and I think that's the crucial issue in this case.
Thank you. Mr. Shravzi?
Judge, Mr. Binger describes it as an unjustified use of a weapon and a threat. I would submit to you neither one of those things are actually true. I don't know if you've seen the video or not. However,
I have.
Okay. So it is a video of him sitting in a vehicle having a conversation with, I believe, Dominic Black. The state in their other acts motion says the 3 things that I think you need to think about, which I believe to be are untrue, which is the state says we would like this admitted for the following reason. The defendant's understanding of the proper use of his AR and of deadly force is crucial to this case. The video demonstrates that the defendant was eager to use deadly force in an unlawful situation. The video demonstrates the defendant fervently sought to insert himself as an armed vigilante into situations that had nothing to do with him. Finally, and perhaps most importantly, the video proves the defendant was ready and willing to use deadly force in situations where it was completely unjustified. That video doesn't show any of that. He didn't have a weapon. He was sitting in a vehicle having a conversation with someone else. He never made contact with those people at CVS. If you watch the video, they don't know, presumably, they don't know he's even there. He doesn't even step from the vehicle to verbally confront them in any way. He doesn't do anything. He doesn't open his window. He doesn't honk the horn. He does nothing but passively sit and watch what's happening. So to say this video demonstrates his willingness to insert himself into these situations, that's untrue. He didn't insert himself. He could have, but he didn't. If you look at the actual situation and you compare it to, and I want you to know this, Judge, there are situations that I think this would be relevant, okay? And it would be admissible. If he had fired around at someone who was simply damaging property, I think we might be in a different spot. That didn't happen. Joseph Rosenbaum, Gage Grosskreutz, and Anthony Huber were not, as far as I can tell, were not looting anything that night. It is indisputable that Rosenbaum was a rioter. Not debatable. And it is not debatable that Gage Grosskreutz was armed with a Glock pistol in his waistband. That is not debatable either. Does the fact that he made that statement 14 days prior and took no action, didn't have a gun, didn't get out of the car, didn't do anything, does that make it more probable that this wasn't self-defense? I would submit to you the answer is no, because, as I've said to you before, this wasn't him taking pot shots at looters. Mr. Rosenbaum was chasing him. That started the whole thing, right? So when you're looking at it, this is Sullivan to a T. Words, the reason Sullivan it wasn't admissible is in one instance it was words, and the other instance it was violence. In this instance, it's words on August 10th, and on August 25th, it is not debatable that there's violence. It, as I said, it doesn't go any further to make a determination as to whether or not that was in self-defense. If he was claiming something else, if he was just saying, my gun accidentally fired, or I was shooting at a looter, I would submit to you that I'd be in a different spot than I am right now. But I think based on the information that you have, based on when you're doing the Sullivan analysis, and actually the fact that we're talking about words versus action, and it is a self-defense claim, as opposed to any other type of defense to the charge. When you compare those things together, it is not relevant for purposes of making a determination as to the ultimate issue in the case, and that is the reasonableness of his actions on August 25th. You can do the analysis as you've already done on the probative value and substantial prejudice as that would occur. I certainly would argue, Judge, that words don't equal action, and just to admit it, to say, look, he's a guy that would shoot at someone. That's propensity evidence. That's not what happened here, frankly. It's not close to what happened here. And for those reasons, I would ask the court deny the motion. Thank you.
I want to respond very briefly, Your Honor, because there is an actual action he takes at the CVS incident, and that is he does call 911 using his personal cell phone while he's watching this incident. Now, he doesn't know what's going on. He doesn't know what these people are doing. He's sitting in a car across the street. He doesn't talk to anybody. No one asks him to call 911. He thinks he sees a crime. His response, in part, is to call 911. His response is also to say, I wish I had my gun so I could shoot these people. Now, we're lucky he didn't have his gun. But the standard for other acts isn't that we have to present to the court an exact scenario that matches the exact crime that the defendant is being charged with as the other act. That is not the bar here. Nor is the fact that these are simply words a bar to admission. For example, if the defendant had said, I'm going to kill Joseph Rosenbaum 15 days before August 25th, and then kills Joseph Rosenbaum, that would be admissible. So the fact that it's words, the fact that it's not action, does not bar the admissibility of this. The key issue in this case is the defendant's state of mind. What was his intent on the night of August 25th? What did he intend with that gun? How did he interpret the threats that he thought were coming towards him? How did he react to them? Were they reasonable? How do we determine what's reasonable? We look at the incident, we look at the defendant's state of mind, we look at his motivations, his intent, his knowledge, all of those things. We don't have a lot of insight into that. The defendant has not given a statement. We don't have a lot of history here, one way or the other. I have sought in my prior other acts motion, and the court has ruled on it, to give some context to the jury as to the defendant's state of mind. This is also part of that. And I acknowledge the court's ruling on my prior other acts motion. The court has denied that, made some rulings on that. This is unquestionably a far more powerful other act. It is a more relevant one. It goes more strongly than even the prior motion to the Sullivan factors, to the relevance, and in terms of undue prejudice here, that is absolutely not even a factor here, because we're talking about the same gun, we're talking about the defendant's own words, we're talking about close in time, so it's not a question of undue prejudice here. This is giving the jury an honest insight into the defendant's state of mind, to determine what his subjective beliefs were, to determine what a reasonable person would do. This is information the jury should have when making those determinations. Now, the court can make a limiting instruction on it. The jury can give it the weight that they feel that it deserves, but they deserve to hear the truth about what the defendant was thinking and what his intent was with this weapon. And let's put this in a larger context, Your Honor, because this was a weapon that he purchased a few months prior. I believe it was in May of 2021. My understanding from the evidence in this case is that he had gone up somewhere in Wisconsin, fired that weapon one time, ever, prior to August 25th. So he's here on August 10th. He's wishing he had the gun. He doesn't have the gun. It's not in his possession because he can't take it to Illinois. He doesn't have a firearms owner ID card. He can't get one because he's not 18. He's storing the gun at a friend's house here in Kenosha, and he's limited in terms of his access to it. He's shot it one time. He wishes he had it on August 10th because he would have used it if he had it that time to stop what he thought was a crime in progress. And then on August 25th, we know what he did with it. So his relationship with that gun, his desire to use that gun, his inability to access that gun is all crucial here in terms of the context and the state of mind here. So when you put it in that context, it becomes even more relevant evidence. And I think the jury is entitled to hear it. Thank you.
Thank you. Once again, I think the evidence is too dissimilar. It becomes propensity evidence. The effort, it seems to me, is being made to show that the defendant is a violent vigilante, and he's willing to employ violence, and he's willing to take matters into his own hands. Although certainly I think I heard now for the first time that he called 911. So he didn't take matters into his own hand. He called the proper authorities. That was not an issue on the date that the incident here in Kenosha occurred, because he could have called 911 all he wanted. There was general lawlessness in the community which was out of control. And so whether he was motivated towards acting as a vigilante in this case, I don't know. That's for the jury to decide, or whether, if they get to that, if it's necessary for them to decide it. But the acts are totally dissimilar, because in the one instance, he's observing what he believes to be a crime being committed. He makes some threatening statements, for sure, and then the one action that he takes is one that is a proper action. The incident in Kenosha, from what I've heard, and I haven't heard what the defense has claimed here, contradicted, is that the incident, I don't want to say started, but the last moments of prior to the shooting, it consisted of the defendant taking a fire extinguisher to try to assist with extinguishing some blazes. I know that there was the night that the furniture, I think it was a furniture store on 60th Street and Department of Corrections building, the firefighters never showed up. I mean, you could call 911 all you wanted. There was no law and order. And I'm certainly not condemning the local authorities here. The police and the fire and the sheriffs acted very bravely, and the people who assisted them. There was simply inadequate personnel to deal with the emergency here. So whatever the defendant's conduct was has to be examined in that light. And whether he assumed a role he ought not have, or whether he did, that's for the jury to sift through. But an incident that occurred, in a peaceful setting where he saw something he believed to be criminal taking place and made some really threatening remarks. Threatening is probably the wrong word. There's certainly statements that could be illustrative of his will and wishes at that time, for sure, and then ultimately took the correct action, versus an incident which is ongoing here in Kenosha in a lawless setting in which he is also engaged in conduct which in and of itself doesn't appear to have been unlawful for him to be trying to extinguish a blaze. And then what followed after that, and as I say, I haven't heard a contrary side of it.
I'll give you one, Your Honor.
Well, go ahead.
Yeah, because that's maybe I haven't made this clear in my motion, but in both of these situations, the defendant is taking it upon himself, taking the law in his own hands, under circumstances where he doesn't know the full facts. He is making assumptions. On August 10th, he's making an assumption, seeing people coming out of CVS, and he thinks they're robbers. And he's talking about taking the law in his own hands by firing off rounds with his AR-15. This is before he calls 911. So his first instinct is, I'm going to stop this with my gun by killing these people, which is completely unlawful. He's not allowed to shoot and kill. Even police would not be allowed to shoot and kill people coming out of CVS pharmacy, even if they just committed a shoplifting. It is not allowed.
You tell me exactly what he said, because I don't remember the statement.
He said,
that he was
bro,
going to kill
I wish
them.
I had my AR, I'd start shooting rounds at them.
Okay. Okay,
So
go
he is
ahead. Go
clearly
ahead. Okay, go ahead.
to shoot at these individuals with an imperfect understanding, an assumption. He has no actual knowledge of what's going on. He makes an assumption. Now, on the night of August 25th, I believe the evidence at this trial will be slightly different than what you've heard. And I do want to contradict the rendition that has been presented to you by the defense. The defendant that night was ostensibly trying to protect a car source location at 59th and Sheridan Road from people damaging that property. He is among a group of people who have stationed themselves with open firearms, most of them carrying these type of AR-15 rifles openly slung around their shoulders. Many of them are on the ground, some are up on the roof. This is sending a message to anyone, stay away from this property, we are armed, you don't want to mess with us. And they essentially are successful in that assignment. That property is undamaged that evening. There comes a time, though, when the police use armored personnel carriers, Bearcats and other armored vehicles to push all of the citizens that are out on the streets south of that location. Police established a barrier at 60th and Sheridan, and essentially everyone is moved south of that and can't get back to 59th. So this car source location, they've now successfully protected, and everyone's gone. So there's no one to threaten this building anymore. However, prior to the police establishing that cordon line at 60th, the defendant and another armed individual, part of this group, go down to 63rd and Sheridan, the other car source location, because they hear whoever was supposed to guard that location is no longer there anymore, and we need to go down there and check it out, maybe protect it. So they go down there. And at some point they try and come back, only they can't get back because the cops have blocked off 60th and Sheridan. So now the defendant is trapped on the other side of that line. He's trapped with this other individual. He can't get back to the rest of his group. His job that night is to protect 59th and Sheridan. He can't do that job anymore. So what does he do at that point? Does he go home? Does he say, okay, it's 11:30 at night, my job is done, I'm gonna get out of here? No. He takes it upon himself to run around in a hostile crowd, a lawless situation, a chaotic situation, with people who have guns, people of varying motivations. He's openly carrying an AR-15 or a Smith & Wesson M&P 15 assault rifle type weapon. He's running around and he's trying to stop people from doing things because he thinks what they're doing is illegal. And maybe it is, maybe it isn't. But at some point during this interaction, he gets into a confrontation with Mr. Rosenbaum and is essentially trying to stop Mr. Rosenbaum from doing what Mr. Rosenbaum's doing. Now that's not Mr. Rittenhouse's job. He's 17. He's not a law enforcement officer. He's not deputized. He's got no training. But he takes it upon himself to take the law into his own hands to confront Mr. Rosenbaum because he thinks Mr. Rosenbaum is doing things he shouldn't do. And this fire extinguisher that he's carrying it along pursuing Mr. Rosenbaum with the intent of stopping Mr. Rosenbaum from doing whatever he was going to do. And that's what leads to that confrontation. The similarity between August 10th and August 25th is in both situations, the defendant took the law into his own hands, or talked about taking the law into his own hands with the same gun to stop things that he thought were going on, that he didn't think should be going on, and he appointed himself a vigilante, taking the law into his own hands in those circumstances. They are identical in that respect. And when we talk about the defendant's motive and intent that night, this is crucial to the case, because that is exactly what is going on. And the defense will have testimony on this. They will say, Mr. Rittenhouse was trying to stop these people. He was concerned about looters. He was concerned about fires. He's going to put them out with a fire extinguisher. He's going to stop these bad people from doing bad things, or so he says. Except that that's not his job. Nobody asked him to do that. He's got no legal authority to do that. His job was done. 59th and Sheridan was no longer in any danger. Go home. But he didn't. He was isolated. He was cut off from the rest of his crew. He was running around with an assault rifle type weapon, a very threatening, aggressive weapon, one that deters people. It is designed to deter people. It is designed to threaten others, to let them know, don't mess with me, look what I've got. Other people that night are carrying around semi-automatic pistols, Glocks, which you can conceal and hide. Other people can't see it. It's not designed to tell people, go away. It's not designed to tell people, leave me alone. You carry around an assault rifle like this, you're sending that message to other people. That's what the defendant was doing. Running around in all this, taking on this responsibility, which he had no lawful authority to do, and making assumptions about what Mr. Rosenbaum was going to do next, or what he shouldn't have been doing, and then confronting Mr. Rosenbaum about that. That is the context here, Your Honor. And the August 10th incident is exactly the same in that respect. Exactly the same in taking the law into his own hands with the same gun, making assumptions about what other people are doing, and taking responsibility to try and stop people when you are not trained, you're not a law enforcement, you're a teenager. It's not his job. So it's exactly the same fact scenario, Your Honor. And I apologize for not making this clearer in my motion, but I think when you look at it through that perspective, Your Honor, you can see why this goes exactly to motive and intent. Now you say it's proclivity evidence, it's propensity evidence. It shows a motive and intent to be a vigilante that night and take the law in his own hands and use deadly force to stop people who are committing crimes that no one is allowed to use deadly force to stop. Police officers are not allowed to shoot shoplifters. Police officers are not allowed to shoot people who are about to set a vehicle in a used car lot on fire. You don't get to use deadly force in those circumstances. You don't get to threaten deadly force in those circumstances. So what Mr. Rittenhouse was doing was well beyond what even the police could have done that night. He took it upon himself. And that is unlawful. It is unjustified. That's what we're talking about here. So that's the exact similarity between those, and that's why the state's asking that the court allow the jury to hear this, because it goes to his state of mind. It shows that he is the type of person who will act to take the law into his own hands. The defense will give their side of the story. They will portray the defendant as this altruistic young kid who came here to try and help. The jury can make the decision, but let's give them the full picture here. And they can make a decision with the court's limiting instruction on this other acts issue. The jury can make a decision here as to what the intent and motive of the defendant was, what his subjective beliefs were, and whether or not they were reasonable. But this information is crucial to the jury being able to make that decision. And they deserve to hear it, along with everything else that's going to be submitted by the defense that's going to portray the defendant in a rosy, innocent, altruistic light. Let's have the full picture here. That's all I'm asking.
So, Judge, I was unaware that Mr. Rittenhouse actually called the authorities on the August 10th date. And I do think that further supports the idea that that evidence would not be admissible. And the reason I say that is the state's position to you in their written motion now becomes further from reality. When they say the video demonstrates he was eager to use deadly force, Not only did he not use it, but as you said, he called the proper authorities. He did what anybody in this room would say you should do if you believe something unlawful is happening. To a T. He didn't threaten anyone because no one who was apparently looting or whatever they were doing was aware of him. The real difficulty I'm having in accepting Mr. Binger's statements are, if we're going to be honest about this, it is not debatable that Kyle Rittenhouse is running to put out a fire. If you're telling me that he is now inserting himself into an unlawful position, we encourage people. I would argue that we would encourage people to put out fires.
But I'm not clear, listening to Mr. Binger, whether he was disagreeing with the statement that the accused was moving towards putting the fire out, or whether he just said he should have gone home. Are you claiming that he was not attempting to use the extinguisher to put out the fire, or
Yes.
intending to do so?
What I'm saying is that in the circumstances before the ultimate confrontation between the defendant and Mr. Rosenbaum, that Mr. Rittenhouse was pursuing Mr. Rosenbaum. Mr. Rosenbaum had not, in fact, done anything. They hadn't even gotten to the 63rd and Sheridan Road car source location. Mr. Rittenhouse had a fire extinguisher. He was carrying it along, pursuing Mr. Rosenbaum, and I believe that he was assuming...
Wait a minute. I thought I heard the first version by the defense was that Mr. Rosenbaum was pursuing the accused, and that the accused had the fire extinguisher. What is it?
Your Honor, our client leaves from 60th and Sheridan with a fire extinguisher. He runs or trots down Sheridan Road, passing Mr. Rosenbaum. This is all on video. There is no interaction between my client and Mr. Rosenbaum. Then Mr. Rosenbaum gives chase, and it's in the video where Kyle drops the fire extinguisher right as he enters the lot of car source number 3, with Mr. Rosenbaum in hot pursuit of my client. There's nothing on the tape, any tape I've seen, if they have something I haven't seen, I'd love to see it, where he has any interaction with Mr. Rosenbaum. And the state says that he was down there earlier with Mr. Balch. I don't know when they're talking about, but when he left the 59th Street car source and went down, the whole thing is on video. He goes to that parking lot, which would be the southwest corner of 60th and Sheridan. There's somebody who confronts Kyle, and he walks away from them, goes over to the gas station. That's where the call comes in. He's never down to the 63rd Street car source. He never has any interaction with Mr. Rosenbaum until Mr. Rosenbaum gives chase to Kyle. That's all on video.
That is actually not, and I'll submit that Mr. Richards is right. He hasn't seen what I'm referring to, although he's got access to it. But on this particular evening, the FBI had a fixed-wing aircraft hovering above Kenosha. We have the footage from that. Counsel can obtain it from Joint Services. I emailed Counsel a few weeks ago and let him know about it.
Yesterday.
What it shows...
Yesterday.
No, I can pull up the email, Mark. I emailed you several weeks ago and let you know about it. The video is an infrared video, and what it shows is
let's get settled when you sent it to him.
I haven't received it yet. We're picking out it after today's hearing.
But I mean, when were you notified that it's available?
I emailed Mr. Richards on September 3rd.
September 3rd, Your Honor, and this was also emailed to me directly.
Okay.
And I was out of the office for...
Go ahead.
What that footage shows, and it's an infrared video because this is nighttime, so infrared is the best way to capture what's going on. What it shows is Mr. Rosenbaum running south towards the 63rd Street car source location. Behind him, probably 20 to 30 feet, is the defendant. Mr. Rosenbaum, upon reaching that location, immediately runs near a parked car. Mr. Rittenhouse follows him, runs to the other side of that parked car, and appears to turn and confront Mr. Rosenbaum. I will note that where Mr. Rittenhouse stops near that parked car is exactly where that fire extinguisher is later found. Okay? So, Mr. Rosenbaum hadn't even gotten to that car source yet. Hadn't had the opportunity to do anything, hadn't done any fires, done any property damage, did nothing. Mr. Rittenhouse is following him with the fire extinguisher, probably because he thinks Mr. Rosenbaum is going to do something. But Mr. Rosenbaum never does. What happens is when they arrive at the car source location, Mr. Rittenhouse turns and confronts Mr. Rosenbaum from across this parked car, says something to him. Of course, we can't see, it's a video from an airplane, so we don't know what happened, but we know immediately upon that confrontation, Mr. Rosenbaum then runs around behind the parked car, and the chase starts at that point in the parking lot. But prior to that, Mr. Rosenbaum was running first, Mr. Rittenhouse was running after him. And I would note, he's running after him with an AR-15 rifle, openly displayed. And Mr. Rosenbaum at no time has a weapon in this entire incident. We know this because obviously the defense wanted to introduce that he was trying to get a weapon. So he never had a weapon at any point. So Mr. Rosenbaum is being chased by an armed individual who is assuming Mr. Rosenbaum is going to do something wrong and wants to stop him, and does in fact confront Mr. Rosenbaum at that parking lot. That is the context here. And the FBI video gives us the context here that we didn't previously have.
Okay, and you said that Mr. Rosenbaum then circled the car, and then the chase began, and who's chasing whom?
At that point then, Mr. Rosenbaum goes around behind the car, starts to chase Mr. Rittenhouse. They run into the street briefly, then cut across the car source parking lot. It's at that point that Mr. Rosenbaum throws that plastic bag towards Mr. Rittenhouse. They then run in between some parked cars, and Mr. Rittenhouse shoots and kills Mr. Rosenbaum.
Well, I still think they're dissimilar incidents. I think that I don't think that they're going to be helpful to the jury in deciding whether the actions of the accused constituted lawful self-defense. The events are so totally dissimilar, and it comes down to proclivity, that's not the word I want, but propensity, thank you, propensity evidence to show that he's a violent vigilante, and he's going to act in accordance with what a violent vigilante will do, and the incidents are so dissimilar, it seems to me that, but on this one I think I'm going to withhold a final decision with a bias towards refusing the receipt of the evidence. And so we can talk about this further at the time of the trial when I've heard more, and perhaps seen some of the footage that you lawyers have been talking about, so I have a more complete understanding. But at this point, if I had to make a decision, and I don't, because this is admissibility, I would deny this admission of this evidence. There's a motion to dismiss count 6 to which the state has not responded, that I saw anyway.
You're right, I have not. I didn't. The issue has come up, and I have responded in the Dominic Black case, which is a identical legal issue, and I filed with the court a brief in that case. But essentially, the law is clear that there's a blanket prohibition on possession of a firearm by anyone under the age of 18. There are exceptions to that, and those exceptions are very narrow. They do not apply to this case. And I think really what the defense motion is arguing is that somehow it's the state's burden to disprove that those exceptions apply. I disagree with that. I think those exceptions are essentially affirmative defenses. If the defense, and the only one we're talking about here is these hunting statutes, which are Wisconsin statute section 29.304 and 29.593. There is no evidence in any way, shape, or form that the defendant was in compliance with those. This is not a situation where a 16-year-old was out deer hunting with his father, for example, which is what those exceptions are intended to cover. So there's, like I said, a blanket prohibition that a minor may not possess a firearm like this, and that's really the end of the court's inquiry, as far as I'm concerned.
All right, no, I'm not going to take further argument on it. I want to read his brief first.
Can we get a copy of that, Judge?
Yes, file a copy of that. I also have the black case, and I haven't been called upon to make a decision. I think it was on for the calendar, got bumped due to a jury trial or something. So I believe I've read that brief before, but I certainly want to read it again, and I certainly want you to have the opportunity to see it. So I'll take that one under advisement also. Next issue is, well, let me ask you about this. Are we ready for the November 1st trial date?
Yes, I believe so.
I believe so.
Okay. Next issue is, it would be my inclination to have the voir dire conducted. I was originally thinking 80 to 100 potential jurors. And I was talking with another judge the other day and mentioned that, and he seemed alarmed. And I think, well, you know, I don't want to shave too closely, so I maybe will bring in more. Maybe I'll bring in 150. I'm not committing to that. But there'll be a large number, larger than could be accommodated in this room. We obviously need to save some seating in the room for the families of those whose lives were lost and for the injured party and for the family of the accused. And some additional seating, and then there's court personnel and security and the like. So I'm going to guess. Do you know how many we've sat in here at maximum? I thought it was 95 or something. Yeah, so around 60 maybe we could get jurors in here. So my inclination would be, if there's no objection, is to have the have the voir dire conducted in the normal way here in the courtroom, with the numbers over, I would probably pick maybe 4 to 6 additional jurors, and then have well, we'd have about 60 to work with. Maybe we can get as high as 70 or 80. We'd work with those here in the courtroom, and that I would have the proceedings televised down to the jury assembly, which can hold a much larger number, and they would be instructed to watch what was happening here, just as they were if they were in the room, and that they're to make a mental note of any to which they would raise their hand. And then if they're called upon to replace a juror, they would be asked, would you raise your hand, and if so, which questions? As if they had been in the courtroom, except that they would actually be participating over the miracles of television. Does anyone have objection to doing it that way?
Here we are.
I don't have a problem with that. Would there be a bailiff or somebody monitoring?
Oh, sure.
Okay.
There'll be plenty of precautions to make sure there aren't any problems. But yeah, okay, that was. I don't think there's actually a right to have it done all in one room, but I wanted to clear it with you folks anyway. The other thing is, I looked at your jury and your proposed questionnaires, which were very good. There were certainly some areas that I did not want to embrace. And I will also tell you that I suspect, due to my age and my longevity, that I maybe have tried more murder cases than anyone in the state. And I've never used a jury questionnaire that I can recall before. And if I did, it was only in a moment of weakness. There are a variety of reasons I'm not crazy about submitting a jury questionnaire. First off, I will tell you that when I do the voir dire, and I do have fairly restrictive views about what's admissible questions. There were some, for example, asking people about support for political groups or protest groups or whatever that I would probably consider off limits, in spite of the fact that there is an aspect of that to this case. I would most probably not permit questions about whether people support a political belief about gun ownership, for example, or gun possession, or membership in particular organizations, unless it's shown to be directly relevant to this case. This is not a political trial. It's not going to be a political trial. I certainly allow reasonable questions that might suggest a witness would be biased one way or another, and that may at times get into some of these areas. But as we know, a political vote is inadmissible under all circumstances. To ask somebody how you voted in the last election or something like that, and whether you made a donation to a political group, I think falls pretty much in the same category. But I don't want to be too blunt about that, because there are aspects to that that could be a legitimate issue. And the other thing, another reason why I'm not crazy about questionnaires, is they're going to forewarn all kinds of people that they're being considered for this particular case. And as somebody referred to earlier on, there's people all over town who are talking about this case. And I have had one person ask me in the grocery store, didn't ask, the person said, I would like to be on the Rittenhouse trial, and I will disclose the identity of that person to you folks. And of course, that person will not be on the Rittenhouse trial. But there are other people, you can tell that they're just itching to talk about it, and that to talk about it a lot. And I also had a conversation with someone from the Kenosha News, because there have been 2 letters published in the paper, which I thought was very irresponsible, that dealt with what the outcome of the case should be by people who have not heard any evidence. And when people in the past have asked me about a case, and it happens rarely, I have always told them, when they tell me how the case is going to end up, or how the case should end up, I always tell them, you've got me at a disadvantage because I haven't heard the evidence yet. And I'm, in a way, I'm insulting them, and I'm hoping that they understand why they're being insulted, because they don't know. And the letter writers that got published had no business writing those letters. But shame on the media that publishes that, and I hope that's not going to happen again. But and there's been some grossly irresponsible misreporting on a few occasions about what happened in this case, and the case has been politicized, as we all know. The questionnaire is only going to get those people who get the questionnaires talking about it. They're told, don't talk about it, but we're always cautious about that. And when I conduct these trials, in some cases that you'd recognize the names, I usually make I have a little discussion about the Bill of Rights, and about which includes the right of the media and the price we pay for having a free media, which is a lot of inaccurate reporting, not because anybody's particularly sloppy, but because of the pressures that they have and the need to get the story out, and the lack of ability to cross-examine, and all the other features. And educating them about how the media, responsible media people themselves would agree that the cases should not be tried in the media. So, and then only then ask them, have you read or heard anything about the case? And I find that very, very rarely does anyone who has read or heard anything about the case state that he or she is unable to put that all aside. And that's what I would expect to do in this case. And I also, there's a line in one of the submissions that says the jury won't be sequestered. That is certainly not my intent. But when we have the jury here, I am going to warn them about that possibility, because I don't want to get halfway through the trial and then tell them, guess what? So I would tell them that certainly that is not, I haven't sequestered juries since it became lawful to try them without sequestration. So I wouldn't expect this one to be sequestered. But I'm not going to tell them they won't be, because it's possible that they could be. So the bottom line is, I feel fairly comfortable that we can get a jury selected in a reasonable time, in a day's time. If we have all the jurors, we won't do it in panels. We'll have them all participating either here in the courtroom or by video. So we won't have to repeat anything, hopefully. And you can follow through on your questions. But that's my thinking, and I invite your reaction, negative or otherwise.
Your Honor, I think the parties are in agreement that a questionnaire is necessary in this case. I don't want to speak for counsel, but I know they've submitted their own questionnaire, and I know that we discussed this at a prior hearing, and I think we've both taken the position that it was appropriate, and the court had invited us to submit them. So I thought we kind of dealt with this already, but I will address it again. I respect the court's experience in trying homicide cases, and I'm well aware of that. I think we can all acknowledge that this is one of the highest profile cases in Kenosha's history. It is one that the events of these nights affected our community in a widespread impact, independent of anything the defendant did. You know, the shooting of Jacob Blake and the subsequent nights of protests and riots and property destruction had affected a huge swath of our community. And so there's not going to be a lot of people out there that haven't heard about it and haven't formed some impressions one way or the other about what happened to Jacob Blake, about what happened to our community, about the various political or philosophical movements that showed up here in response to all of that. It's probably oversimplifying it to say that most people fall on one side or the other of the spectrum, but certainly a large percentage of our population feel strongly one way or the other. There are clearly some that are not invested or don't have an opinion or whatever the case may be, but I think it's fair to say that this is an issue that is a polarizing one, these events, and they've crystallized around the defendant. There are some portion of the population that, for the way they see the world, his actions fit and are justified, and there's some portion of the population who see the world and his actions are unjustified. And I agree with the court. I'm not here to argue any of that. I'm concerned about what the law says. I'm concerned about justice in our criminal system here, and I believe that our charges against the defendant are appropriate, and I think that we will prove him guilty. But I don't need to get into a debate about the political movements or about Jacob Blake or about any of that stuff. But it would be, I think, naive for us to ignore the fact that the 100 or 150 people that you bring into this courtroom are all, not all, but most of them are going to have opinions and knowledge. And a jury questionnaire is important to help the parties make our important decision in this case with enough time and to deliberate and to evaluate, to investigate, and to make a decision about those jurors. In the heat of the moment in voir dire, we may have a juror who doesn't answer a single question, who doesn't raise their hand. We've all seen that happen, where there's a member of the panel who never responded in any way to anything. And we don't really know at that point. We've got a little bit of information, maybe we've got a name or an address or an occupation, but other than that, we don't get a lot. If this were a misdemeanor retail theft, I could live with that. But the stakes obviously here are much different. So I believe that a jury questionnaire is important, and I would urge the court to finalize it, and I think it's important that we get it out the door with enough time to give the jurors an opportunity to fully respond to it, because both of these submissions are 10, 15, 20 pages in length. It's going to take some time, and then it's going to take time to get back to us, and of course time for the parties to review that, and the court to review those, to make some evaluations of those individuals. But I see this as a unique situation in which this is important information that we're going to need in advance. We have set aside a couple weeks for this trial. I don't know if that's going to be enough time or not. We'll see. But I agree with the court that we want to try and do voir dire as quickly and efficiently as possible, and a questionnaire is going to be incredibly helpful in that process. I understand the court's concern that we're tipping off potential jurors, that this is the case they're being called on, but that's inevitable. And they show up on Monday morning, they're going to know. They're going to see it very quickly. I do believe, however, that no matter what we do here, it's important that we protect the jurors' confidentiality, we protect their safety, and I know we've had some discussions about that, but one of the things I wanted to bring up is during voir dire and during this entire process, I think it's important that we refer to the jurors only by number and not by name, because I think there is a serious risk in this case that if their identities become published, and in today's day and age, the internet is the bane of our existence in the sense that anybody can put anything out there, home addresses, phone numbers, family members, etc. It makes jurors particularly vulnerable in today's day and age. So I think that no matter what we do, we need to make sure that we only refer to them by number in open court. Thank you.
Thank you.
Judge, so one of my last trials, we used jury questionnaires. While Mr. Binger's right, it's helpful to the lawyers, and I agree with him on getting them, by the way. What it was, though, was enormously helpful to the court. And the reason it was helpful to the court was everybody had heard about that case like everybody will have heard about this case. And the people with the strong positions on the case have provided that to you and to the parties in writing. And what they weren't able to do was poison the entire panel by saying, I've heard about the case, I think X or Y about this case. So people who had strong opinions, we were aware of it ahead of time. The judge was able to, if she needed to in that case, to do individual voir dire on those people, so they didn't poison, in this case, 150 people about what was going on. That's what was really helpful in a case where everyone's going to have heard about it, so when you ask that question, every hand will go up. I would submit to you the majority of people have an opinion one way or another, and what I found to be really helpful, and that was Judge Ryder on a case where we were able to separate those people out pretty quickly, and she was able to ask them, would you be able to set this aside? Would you be able to do this? Without having to worry about their statements influencing other jurors, if they had heard things about the case, talking about those things that they had heard, which clearly wasn't evidence at that point, right? So I think everybody in that case found it useful. That's the reason that we had suggested it here, because I don't think the type of case matters as much as the publicity behind it and the strong feelings one way or another. So I agree with Mr. Binger that I think it's appropriate because I think it'll help you at the end of the day. I think it'll help us to make sure we're not poisoning people. I don't know if you want to address the issue regarding anonymous jurors. I'm only really here to talk about the jury questionnaire thing, but I think at the end of the day, you would find it to be, you might not have used it, but I think you would find it to be useful in trying to make sure that you do get an impartial and fair panel.
All right, well, let me take a look at it. I've given you my thoughts. I've heard what you have to say, and don't want to grab control of the case away from you guys. Let me think about it, and I'll make a decision by Monday or Tuesday. And then if that's done, then you'll get a composite of what I think are acceptable questions. There's some that I'm not even going to go into right now. And we can discuss later if you feel that disagree with the decisions I make. Anything else today?
We were going to set a date for the Daubert.
Date for the Daubert. I would guess so.
Is your Mark? Is your witness in Washington or is he here?
He's in Washington. I would have him here by Zoom.
Judge, with regard to the Daubert motion, the witnesses that are proposed as experts, could they appear by Zoom?
Yes.
Thank you.
What about Tuesday, October 5th?
What time are we thinking?
I'm thinking 9:30.
If we could do like 10, I've got an appointment I have to do at 8:30.
Okay, I could do 10 to noon. I got a couple hours there.
Okay.
I'll just move my other hearing I got.
All right. Anything else today?
I'm waiting for the state.
That's fine. Does that work for you?
I'm at a trial, but who knows if it's going.
Here.
Okay. Thank you very much.
Thank you, Your Honor.
That's
All right, thank you.